What you are about to hear is not another routine courtroom dispute or a forgettable procedural clash that fades with the next news cycle. This unfolded in the opening days of January 2026, and it marks a moment many legal scholars are already calling a breaking point for American institutional authority. Because inside a packed federal courtroom, a former president did something no modern political figure has ever dared to do so openly. He refused to recognize the authority of the judge presiding over his criminal case. And when federal marshals stepped forward in response, the room froze in what veteran court reporters described as one of the most tense confrontations they had ever witnessed in decades of federal proceedings. And this was not theater. It was not symbolism. It was a direct collision between personal power and the rule of law, a collision that forced armed federal officers to prepare for physical intervention because a defendant, who once commanded the executive branch, chose defiance over compliance. And that single decision shattered every expectation Americans have been taught to hold about presidential conduct after leaving office. This moment did not erupt out of nowhere. Tensions had been escalating for weeks inside Judge Aileen Cannon's courtroom, driven by bitter disputes over classified evidence, aggressive motions from prosecutors alleging obstruction, and a defense strategy that increasingly framed the judiciary itself as an enemy rather than an arbiter. But everything detonated during a critical pretrial hearing in early January 2026, when newly declassified FBI materials were introduced. Documents that prosecutors say reveal a pattern of deliberate concealment rather than accidental retention. Materials that allegedly show Donald Trump personally directing the movement of top-secret documents from secure storage areas into unsecured personal spaces at his private residence for well over a year after leaving office, despite repeated federal demands for their return. And when those details were reviewed in chambers during a recess, courtroom observers say the atmosphere shifted from tense to combustible, because judges do not issue direct rebukes of this magnitude unless they believe the integrity of the entire judicial process is under threat. When the judge returned to the bench, the room followed standard protocol. The bailiff called for everyone to rise. Every attorney stood, every journalist stood, every court officer stood, and Donald Trump remained seated, scrolling on his phone. And when the judge instructed him to stand, not once, but twice, he looked up, made eye contact, and refused, openly declaring that he did not recognize the authority of what he called a kangaroo court. Words that cut through the courtroom like a blade and instantly transformed a procedural moment into a constitutional flashpoint. Because that is when federal marshals stepped forward, their movement alone enough to trigger visible alarm among Trump's own attorneys. Because when marshals advance toward a defendant's table, it signals that escalation is no longer theoretical. And at that moment, the justice system found itself confronting a scenario it was never designed to face. How do you enforce basic courtroom authority when the person defying it is a former president who still commands intense loyalty from millions and frames every act of accountability as persecution? This is where the historical comparison becomes unavoidable. Richard Nixon complied with court orders even as his presidency collapsed. Bill Clinton appeared for depositions even when he resented the process. Other Democratic leaders around the world, from France to Israel to South Korea, have followed courtroom protocol while loudly protesting their innocence outside judicial chambers. But none stood before a judge as a criminal defendant and openly rejected the court's authority itself. And constitutional scholars are warning that this is not just another Trump controversy. It is a categorical rupture with 235 years of American constitutional tradition. Because the judiciary's power does not rest on force, it rests on collective acceptance. And once a high-profile defendant rejects that acceptance in front of cameras and armed officers, the damage cannot be easily undone. Ask yourself this in the middle of this unfolding crisis. If a former president can decide which courtroom rules apply to him, what happens when ordinary defendants demand the same exemption? And what happens to a system that depends on equal treatment to function at all? The newly revealed FBI evidence only deepened the conflict because prosecutors argue it shows Trump personally instructing aides to relocate classified materials multiple times, including documents allegedly involving nuclear capabilities, foreign intelligence assessments, and military operational plans. Materials investigators say were kept not for oversight or record-keeping but for personal leverage and narrative control. And when that context is combined with his courtroom defiance, former intelligence officials warn it reflects a mindset that treats national security access as personal property and judicial authority as optional. A mindset that democratic systems cannot survive. The fallout spread immediately beyond the courthouse. Republican leadership reportedly fractured behind closed doors, some figures rushing to defend Trump's defiance as righteous resistance. Others warning that openly attacking judges and marshals could devastate the party's credibility with independents and institutional conservatives, while Trump's base erupted online, calling for investigations into judges, attacking federal law enforcement, and amplifying claims that the justice system itself is illegitimate. Language that experts on democratic erosion say mirrors the early stages of institutional collapse seen in other countries. Meanwhile, federal law enforcement found itself trapped in a vice between duty and optics, between what the rulebook demands and what the country might explode over if that rulebook is enforced in the most visible way possible, because marshals are trained to escalate when judicial commands are ignored, step by step, warning by warning, until order is restored, and that escalation ladder is built for ordinary defendants who do not come with a security perimeter, a political cult of personality, and an entire media ecosystem poised to reinterpret restraint as oppression. Yet no protocol fully accounts for a former president flanked by Secret Service protection, surrounded by loyal attorneys, and followed by a mass political movement ready to interpret any enforcement action as tyranny, not as procedure, not as neutral court management, but as proof of a conspiracy. And that is the pressure point that makes this moment so dangerous, because the marshals are not just enforcing a judge's instructions, they are standing at the intersection of law, politics, and perception, knowing that one wrong move could ignite a national spectacle, and one weak move could permanently undermine the authority of the court. Legal analysts warn that this hesitation alone risks creating a two-tier justice system where power dictates compliance, where the rules are technically the same on paper but functionally different in practice, because the most famous and politically protected defendants get extra patience, extra caution, extra delay, while everyone else would be corrected instantly. And once that perception takes hold, it spreads, it hardens, and it becomes an infection inside the public's trust, because courts cannot survive on paper authority alone, they survive on legitimacy. And legitimacy collapses when Americans start believing the law is negotiable for the powerful and unforgiving for the powerless. Pause for a moment and consider this question, not as a partisan talking point, but as a system test. If the courts cannot enforce basic decorum against the most powerful defendant imaginable, can they truly enforce it against anyone else? Against the unknown defendant with no cameras, no security detail, no political movement waiting outside, no donor class ready to spin the narrative? And if the answer is no, even partly, then the damage is not limited to one courtroom. It becomes a message to every defendant watching that compliance is optional if you can generate enough noise, enough backlash, enough fear, enough chaos. The legal consequences now hanging over this case are enormous because contempt of court remains on the table, and contempt is not symbolic. It is the judiciary's blunt instrument for defending its authority when words fail. Pre-trial release conditions are under review, which means prosecutors and judges will examine not just the underlying charges, but the defendant's behavior in court, his willingness to follow instructions, his likelihood of disrupting proceedings, and his capacity to intimidate the process through spectacle. And every judge overseeing Trump's other cases must now factor in the reality that he has demonstrated a willingness to openly defy judicial authority. A factor that traditionally influences everything from bail determinations to security protocols, from how close deputies stand, to how sharply warnings are delivered, to whether the court imposes tighter rules on public statements that could poison juries or inflame threats. That is how one act of defiance metastasizes, not just into headlines, but into concrete restrictions, heightened security, and a harsher judicial posture. Because courts learn, and once they believe a defendant will test limits, they respond by tightening the limits. And even legal scholars sympathetic to Trump concede that this behavior crosses a line that should alarm Americans regardless of party, because rights do not include the power to dismantle the authority of the courts themselves, and free speech does not include the right to treat courtroom orders as suggestions. In a functioning system, you can challenge a ruling, you can appeal, you can argue, you can fight the case with every legal tool available. But you cannot rewrite the rules in real time by refusing the basic commands that keep proceedings orderly. That is the difference between legal resistance and institutional sabotage. And if the public cannot tell the difference, then the system becomes vulnerable to the loudest actor in the room, not the strongest evidence in the record. Trump's response after leaving the courthouse only intensified the crisis, launching attacks against the judge, the marshals, and the legitimacy of standing for the court itself, framing basic courtroom protocol as a constitutional violation, a claim legal experts immediately dismissed as dangerously unfounded. And when a defendant responds to judicial warnings not with compliance but with escalation, judges tend to interpret that as evidence of risk rather than righteousness. This is no longer just about classified documents or one man's legal exposure. It is about whether the United States still operates under a system where law binds power, or whether power now dictates which laws matter. And that question is no longer abstract. It played out in real time in a federal courtroom in early January 2026, in front of dozens of witnesses, armed officers, and a nation already polarized to the breaking point. So let me ask you directly before we reach the end of this. Do you believe enforcing courtroom rules against a former president protects democracy? Or do you believe making exceptions for political power is the only way to avoid chaos? And what happens if those exceptions become permanent? Because here is the reality. A former president openly defied a federal judge, marshals prepared to intervene, and the country now waits to see whether the judiciary will assert its authority or retreat under political pressure. And whichever path is chosen will shape the meaning of equal justice under law for generations. So, as this story continues to unfold, and as rulings are expected in the coming days, keep watching closely. Because this is not just another headline, this is a stress test for the American legal system itself, and the outcome will tell us whether the rule of law still commands obedience when it collides with raw political power. And now I want to hear from you at the end. Should any individual, regardless of office held, be allowed to decide which courtroom rules apply to them? Or is this the moment when the line must finally be enforced, no matter the consequences?